Let's head west to California, where Nick Reiner was supposed to be arraigned yesterday, but instead of getting arraigned, we had an attorney withdrawal. Alan Jackson, his high-profile criminal defense attorney, the guy who represented Karen Reed successfully and got her a not guilty last summer, had been hired. We talked about, geez, how can he afford this? I think we all agreed somebody was paying him because he doesn't do pro bono, even if it's going to be for a lot of attention. And now he bails, saying, actually, it's not going to be me. And he offered a little bit more. He wouldn't say why. He said he was prohibited by ethical rules from explaining why, but he's out. A public defender is in, and he offered the following in SOT 31 on his way out.
I'm legally and I'm ethically prohibited from explaining all the reasons why. I know that's a question on everybody's mind. We expect the public defender to step in. They've already been appointed and very capably protect Nick Reiner's interests as he moves forward through the system. But be clear, be very, very clear about this. My team and I remain deeply, deeply committed to Nick Reiner and to his best interests. What we've learned, and you can take this to the bank, is that pursuant to the laws of this state, pursuant to the law in California, Nick Reiner is not guilty of murder. Print that. Print that.
Okay, I just want to say that, Alan, you can save your righteous indignation for a case that doesn't involve a young man who clearly nearly decapitated his parents. Okay? Because this is not a media problem for your client.
Right.
It's you took a knife and murdered your parents, loving parents by all accounts, problem. So just stop with your, the media, print that. Okay, all right. Exit stage left, goodbye. So I gleaned there, Phil, actually this is for Dave, that he made a distinction between factual innocence and legal innocence.
Right.
That's why he said pursuant to the law, which I had some friends, multiple actually, send the clip to me confused. Lay people didn't quite understand. They thought he was actually saying he didn't do it. And that's exactly what he wanted them to think, Dave.
All true. We're in total agreement on that. This is a lawyer who is known as a true believer, right? And you can see by his comments, he didn't have to go there. He's not working for them anymore. And yet he had to say, not guilty of murder. Well, okay, if he's legally insane, then he would be not guilty. If it's manslaughter, it would be not guilty of murder. So that's where he's going. As far as why he withdrew, I think Phil, Ashley, and I are all in agreement. It had to do with money. The family out of the estate was apparently paying his fees, and they probably decided, you know what, it's not worth it anymore, especially if you hire a pit bull like this who may turn the spotlight on the Reiners, the victims, and perhaps try to accuse them of something untoward. We're not paying for that. So I think that's the reason why he's out. It's because of money.
Yeah.
And who is going to drain the family trust down to God knows what, Phil?
Well,
I mean, this kind of a defense could cost several $1 million.
Oh, yeah. I mean, millions and millions of dollars. And that type of grandstanding is not my style. I understand other people's might be inclined to do it, particularly when they're on the courthouse steps with the cameras rolling. But that being said, and I said this on your AM update this morning, and to expand on that, look, he would have had to do, there's two reasons. It could have been a conflict of interest, or it's going to be money. Those are the two things that come out and make sense to me, theoretically. So he's going to have to do a conflict check going into the case before he can take on a client. A lawyer is supposed to make sure they don't have any conflicts of interest that would keep him from taking the case. So presumably he did that. He's no slouch. He would have done that and would have known about a conflict of interest, unless in the unlikely scenario that maybe a conflict arose in the last couple of weeks, which seems unlikely. But he was right there, Johnny on the spot, representing Nick Reiner right after this happens. And so to me, that suggests that there was some money promised that was not delivered for whatever reason. It could be that the heirs of the estate have decided that they don't want, presumably this is all in a trust. They may be trust beneficiaries, and they don't want the corpus of that trust being spent on his defense. And so the heirs may not be in agreement, or the money just may not be there, or for whatever reason, he did not get paid what he was expected to get paid. And so that's why
we
he's
kind
out,
of know
in my
it was
view.
money, don't we, Phil?
Yeah.
Because they didn't replace him with another storied defense attorney out in California. They replaced him with a public defender.
For now, and there may be a retained lawyer that gets in later, but in the short term, it makes sense for the court to go ahead and have a public defender do the arraignment, and they can always hire another lawyer later. But you remember, Jackson was right there going to the crime scene and all this, having the cameras follow him around right after this happened when it was in the spotlight. And so I'm sure that discussions were had about what my fee is going to be. But then when Mr. Green did not get delivered as agreed, then, suddenly he has to get out. And that's, in my opinion, there's a lot of speculation. It's educated speculation, but I think that's what happened.
Oh, yeah.
Okay, so, but what the most interesting thing, because no one really cares about the lawyers, Ashley, but the most interesting thing is the telegraphing of what the defense is going to be.
Right.
And it seems pretty clear he is telegraphing that he's going to plead not guilty by reason of insanity. Now, I really do want to talk about this because we talked about it when this case first went down. And we talked on this program about the insanely high burden to prove that. The defense would have to prove it. Usually in a criminal prosecution, the burden of proof is on the prosecution. But if you're going to plead not guilty by reason of insanity, the burden of proof is on you as the defendant. And it's so high. It's high in all courts in California, very, very high. We talked about a case in which a guy was like sucking people's blood. He drank the blood of a rabbit.
Yeah.
Like they were like, nope, not insane enough for us. You're guilty. So it's very, very high. But that was before we learned that he had switched his medication allegedly right before the murders and had been going kind of nuts.
Right.
Like his behavior had been escalating. Will that matter, the medication twist?
Yes, it actually could matter significantly. And the reason is, as a defense lawyer, you have to make an analysis. You have to really decide if you want to do if you want to do this type of defense, if you want to go forward with a mental health defense. And the reason is you might end up serving longer in jail than you would otherwise. Let's just say that if he went to trial without this defense, this psych defense, he could get life with the possibility of parole. Well, let's say that he was committed. He was found not guilty by reason of insanity, and he was committed. He's not released until he is no longer a danger to himself or others. If it was a medication issue, he could be properly medicated, and then he could be released quickly. But if it's one of those issues that actually isn't related to medication, it's very hard. You can't really cure someone. And so then he would be facing a much longer time in prison, potentially the rest of his life. So, normally the decision's not that difficult in a case of this caliber. But if you have a client who's charged with something like, let's say, a theft or a drug case, and they have a mental health defense, a lot of times you don't want to use it because they might actually stay in custody in that actual mental facility far longer than they would if they just pled guilty and did the time. So I think that might have factored in. I also think this mental health defense might factor into why Alan Jackson had to leave, because it's not just the lawyer's money. When you're a private attorney, you also have to have money for the experts, and mental health defenses are extremely expensive. And so the family may not have been willing to pony up all that extra money. Or if it's the public defender, the public pays for it. You get court-appointed experts. So that may have also factored into the decision.
I don't know though, Phil. I enjoyed your interview on AM Update this morning. I listened to it as a consumer because Emily Jashinsky does AM Update on Wednesday nights into Thursday. And I thought it was good. And you were making very good points about, we didn't discuss the medication specifically, but they're going to ask whether he knew right from wrong the day of the murders and when doing the murders. And you were making the point that there is plenty of evidence he did, medication or no medication.
Yeah, we actually talked about that. I think it may not have made it into the final version of AM Update, but Ashley's point's correct. He's going to approach this. Any lawyer, I say he, it could be a she. There's a female court-appointed lawyer now, and whoever the lawyer is, he or she or maybe the group of them, are going to have to pursue two things. Did he know right from wrong? Was he insane at the time this happened, if he's the one that did it? And even if so, is he now presently competent to stand trial? In other words, can he assist in his defense? If he was acutely under the influence of some type of chemicals that caused some type of psychosis at the time, that's not going to excuse him from criminal responsibility. But even if it did, or if there was something else, we have evidence that shows he took steps to hide his behavior and to hide the crime such that he would have known right from wrong. And so that's going to, I think, destroy any insanity defense. Well, I think he kind of went to a hotel, right? And he took, they say he shut the blinds and did all these things right in the aftermath to kind of get himself away from it. In other words, it's hiding behavior, and it's the type of thing that shows a consciousness of guilt. But as far as the competency to stand trial, if he's under the influence of drugs to the point that he's just out of his mind.
Which, just to be clear, is a different issue. It's a different issue than pleading insanity as your main defense.
But they would do both.
First, they have to cross the bar of, can you even stand trial, or are you too far gone?
Yeah, they would do
to
both.
Do that? Sorry,
and if he's under the influence of substances to the point that he can't assist his lawyer, well, that's temporary. You put him in jail, and you remove access to the drugs that he's on, at least the ones that, the illegal drugs that cause psychosis, then that can pass. That can be a temporary kind of situation that resolves by the time he goes to trial.
Dave, your thoughts?
I would argue that his actions in advance of the murders also shows that he was not legally insane, because he had a heated argument at that party with his parents. So there's the motive. Got in a fight and he acted on it. So I think, based on what Phil said, which is his attempts to evade afterwards and his actions beforehand, it shows that he knew the difference between right and wrong. It's going to be very hard for him to be found not guilty by reason of insanity. Much easier for him to be found not competent to stand trial, which is a different standard, as you guys said, which is whether he can assist in his defense and whether he understands the nature of the proceedings in front of him. So that the public defender may just try to say he's not competent, let's send him to the mental institution
what happens
for
then,
years.
Dave?
Well, you get sent off to a mental institution until you're brought back to competence. And in Florida, which I think California is similar, that this could take years. That's why this trial isn't happening anytime soon. And if he's never brought back to competency, then he could be set free at some point.
A new year means new financial goals, like making sure your savings are secure and diversified. Will this be the year you decide to talk to someone from Birch Gold Group? They use an educational approach with a deep understanding of macroeconomics. There are forces pushing the dollar lower and gold higher, which is why they believe every American should own physical gold. So until January 30th, if you're a first-time gold buyer, Birch Gold is offering a rebate of up to $10,000 on qualifying purchases. To claim eligibility and start the process, you just text MK to the number 989898. Birch Gold can help you roll an existing IRA or 401k into an IRA in gold, and you are still eligible for a rebate of up to $10,000. Consider making right now your first time to buy gold and take advantage of a rebate up to $10,000 when you buy before January 30th. Text MK to the number 989898. Claim your eligibility today. Again, text MK to 989898. Thanks so much for watching. If you like what you just saw, hit the subscribe button for more clips and full episodes.